Mistake number 2, not properly funding your trust. So what we're going to talk about now are revocable living trusts. And these are commonly promoted, especially by financial advisors, on a nationwide basis. What's important to understand is that trusts are not one size fits all. No estate plan is. And whether a revocable living trust is right for you is really dependent upon what your circumstances are. In Washington, where I practice, oftentimes we will not recommend a revocable living trust, and that's for a couple of reasons. One of the reasons may be that in Washington, the only way for you to protect assets for your spouse when you're gone against long-term care expenses in the state is if you create this special kind of trust through your will and not through a revocable living trust. And that's a topic for another day. But that's one of the reasons not to do a revocable living trust in Washington. Another reason not to do a revocable living trust in Washington is our probates are so simple here. So a revocable living trust, the primary purpose of it is to avoid a probate. And I'm sure we've all heard that probates are bad and to be avoided. We'll talk a little bit more about that. So first of all, let's talk about, the mistake with revocable living trust. And let's assume that the revocable living trust is the right estate plan for you. So what goes wrong? What goes wrong is that people don't fund the trust. In order for a revocable living trust to work and do what it's supposed to, assets have to be in that trust. So for example, your bank account must be retitled in the name of the trust. Your house too. So let's say you and your spouse create a revocable living trust. Your names will be on all those assets. Well, you have to change the names on those assets. You have to change it now to you and your spouse as trustee. You have to do a quit claim deed on your house to change it from your name and your spouse's name to you as trustee and your spouse as trustee. And oftentimes that doesn't happen. The trust doesn't get funded. And if the trust doesn't get funded, then the trust isn't working like it's supposed to work. It's not managing those assets. One of the reasons that people don't understand this is that, this trust, it's like a separate legal entity, yet it's not. I mean, the assets need to be titled in the name of the trustee of this trust, but the trustees, they don't have to do a tax return. They don't have to get its own tax number. They're just, and frankly, they don't understand how a trust works because it's kind of esoteric. How does a trust work? So that's one of the reasons that trusts don't work. The main reason is because they don't get funded because people don't understand that they have to fund them. So even though the idea is that a trust is supposed to simplify your estate plan, it can paradoxically make it more complicated. A trust is supposed to help you avoid a probate, but if you haven't funded the trust, you will not avoid probate. You're going to have a trust administration and a probate. So with a lot of estate planning problems, the reason that they don't work correctly is people do it-yourself forms, or people buy, online forms and get like an hour consultation from somebody who may or may not be a lawyer, and they're just not going to take the time to explain all the things that you need to understand. So with a lot of things, getting good estate planning counsel is going to go a long way to make sure that you don't run into these problems. So let me give you a couple of examples of revocable living trusts gone wrong. So here is another single gentleman, and somebody recommended for him, and he got a revocable living trust. Now, he was a single man, he had no children, but he had lots of nieces and nephews. I think it was 18 nieces and nephews. So for him, avoiding probate would make sense because, see, when you're doing a probate, the will is filed with a court, and then the executor needs to give notice of the fact that there is a probate to what are called the heirs at law. And so for this gentleman, his heirs at law were his 18 nieces and nephews. So that's a lot of work. And especially in this case, it wasn't what he wanted because he just wanted his one favored nephew to get his house in his bank account. So a revocable living trust would have made a lot of sense. But you can kind of guess what happened here is that neither the bank account nor the house were put into this trust, so the trust had no effect. So his estate did need to go to probate, and we did need to notify the 18 nieces and nephews that the one favored nephew was going to get it all. So I really can't tell you why a revocable living trust was recommended to this gentleman. Maybe it was on the relatively inexpensive side, that being, $500 to $2,500, and somebody said, hey, this is a great idea. I know that had he come to us and had we done his estate plan, it would have been very simple. We would have recommended that he have his one bank account pay on death to the nephew, and we would have recommended that his house do a similar thing. Not go through probate, not be put in a trust, but do what's called a transfer on death deed. And if you record a transfer on death deed before his death, then on his death, his house would have gone virtually automatically to that nephew. And there would have been no estate administration, no trust administration, no probate. It would have been very, very simple. So, sometimes what we do as estate planning lawyers is we do avoid probate because there's no benefit to a probate. And this is a good example of no benefit to either a trust or a probate. Yeah, basically a revocable living trust was not the right thing for him.